All right. Cool. All right. I think we are about ready to start. People are joining us right now.
Hi, everybody.
Hi, everyone. Welcome. I'll give it a little time. I think more people are coming in. Oh my gosh, so exciting to see everyone's names.
Such a fun topic. It's the letter that everyone wants to get in the mail, right?
No, no, no. Oh God. Oh gosh. All right. Okay. Do you think we're about ready to get started then?
Let's do it.
Okay, cool. All right. So welcome everyone. Thank you for joining us on a beautifully sunny Tuesday afternoon. At least it is for us over here in California. Um, yeah, so today we're going to be talking about a topic that I think is really interesting. We're going to be breaking down a cease and desist letter, breaking down its purpose, its power, its pitfalls. If you've never gotten a cease and desist letter, beautiful, amazing, keep it up. But if for some reason you have gotten one, or if you would like to send one, you were in the right place because we will be talking about these letters. Okay, so welcome everyone. I think we will quickly go over some housekeeping. Um, yeah, so we'll have a Q&A at the end of the presentation. So if you have any questions, feel free to submit them via the Q&A function down at the bottom. After the end of this webinar, everyone who's attended, or I think everyone who has registered, will be receiving a link to the recording along with this PowerPoint presentation. So if you need to step out, if you need to leave early, don't fret. You will be receiving some materials, and then we'll be offering an opportunity to dive deeper at the end. So stay tuned if you can. Okay, introductions. You must be wondering who am I listening to? So let me introduce who will be talking. So Nina Ameri is the founder and principal of Ameri Law PC, the firm that is putting this webinar on. Nina is a well-known and respected attorney with 20 years of experience practicing law. Opening up her firm back in 2019, she has dedicated her practice to helping creatives within the entertainment industry build their brand and understand their contractual rights as they embark on creative endeavors. Not only does she help her clients protect their intellectual property through cease and desist letters, but she also guides clients through other processes like the federal copyright and trademark filing process. Next up is Caitlin Bradshaw, who is an associate at Ameri Law PC. Having grown up in a family with a deep passion for music and art, Caitlin developed her own passion in helping creatives and artists retain their rights to their work. It was this experience that led her to law school to become an entertainment attorney. And since starting at Ameri Law as a law clerk in 2022 and then an associate in 2024, Caitlin has been able to gain wide-ranging experience on numerous types of entertainment contracts and intellectual property matters. Last and hopefully not least is me, Kyla Nguyen. I'm also an associate at Ameri Law PC, and I have a passion for entertainment born from my love of art, literature, and music. Growing up, I always wanted to be an artist and a novelist, but eventually I found my passion advocating for creatives. But as someone who is creative myself, I understand how important it is to enforce the rights that you have in your work so you can continue to create peacefully. Yeah. As for why are we here, I will let Nina take it away.
Well, I really appreciate everybody being here. I know this is a hard topic for a lot of people. Cease and desist can be really scary. We have clients, that are either wanting to send them or have received them. And there's just a lot of questions that we were asked all the time. So we thought this is a great topic. So, a lot of times disputes arise because number one, people don't have contracts, right? So people, start, I guess we can say they get married to each other without dating. And maybe it's former collaborators, maybe it's a big studio going up against the little guy, but a cease and desist letter is really the first step um, when somebody is infringing on another person's rights. It's usually a kind of a precursor to a lawsuit, or sometimes it's a, I guess, gateway to some kind of settlement or resolution. We see them all the time. There's a lot of people that it's instant fear. Some people want to instantly comply. Some people ignore them and are dismissive. And so, because there's so many different reactions, we thought let's give some practical insights into what these letters mean, how to navigate them. And I think just with the way the entertainment industry is always changing, I think that people are going to go towards these kind of low cost measures to enforce their rights more so than ever. So let me start by just kind of laying out what exactly is a cease and desist letter. It's basically a letter that tells the recipient that they've done something wrong. Um, the sender is going to take legal action if they don't stop. Most often, it's used in cases of infringement of intellectual property. It could be defamation. It could also be used in the context of someone not complying with a contract. So sometimes we'll see like a demand slash cease and desist letter. If you don't respond to them, guess what? They can lead to litigation. If someone doesn't get a response, their next step could very well be filing a lawsuit against you. You may have to comply to just avoid further damages. Um, and you know, bottom line is that these can really impact your own intellectual property and your business operations if you don't pay attention to them. um, Non-legal consequences are oftentimes even more important, right? So you're going to damage your reputation if the public gets wind of your infringing behavior. Just general disruptions to your business, branding, your creative work, um, could lead to lost opportunities, and of course, legal fees, which no one likes to pay, but you are going to have a lawyer help you navigate this. So, what are some of the goals of the cease and desist? Number one, it's really to stop infringement or wrongful conduct. Um, a lot of times, you will have a person that is maybe we'll use an example from the film business. Um, you're using somebody's script and you didn't pay them for it. um, in the business context, you're using someone's trademark or trademark that looks similar or a logo that looks similar. Um, by sending the letter, this is going to protect that sender from you continuing that conduct. Um, if you are a intellectual property owner, one of the ways that you have to kind of one of the ways that you have to ensure that you maintain your intellectual property rights is enforcement. So once you get, for example, a trademark registration, and if you get wind that somebody's infringing on you and you don't go out and send cease and desist, you don't try to stop them, guess what? You can use your rights. So inaction, no bueno, you can lose your rights. Um, the thing that often happens with these cease and desists is people don't want to go to court. It's expensive, it's timely. This is a way of opening the door to negotiation. So, a lot of times it is actually better for you to respond and hopefully maybe end up in some kind of a settlement with these folks that are sending the cease and desist. All right, so this is something fun and new that we've been trying in our webinars. We want to do a little bit of a pop quiz. So get ready. What is one of the common goals of sending a cease and desist letter? I know the answer, but I want you to choose.
People are, oh my gosh, a lot of people are participating. Okay, cool. They're using the polling feature. Um, okay, we have a good amount of answers. There, there seems to be an answer that's in the lead. I don't know. Can you guys see the poll results or is it just me?
No, just
Okay.
you. I can't.
So,
I can't wait to find out.
okay, let me end poll because I think we got a majority coming in with answers. End poll. It looks like C was the most popular answer, and that's correct.
We learned
All
something,
right.
didn't we?
What a enraptured audience. But yeah, C. Cool.
Okay, so I will kind of go over what is in a cease and desist letter. So most often, it's going to start out with a claim, right? It's going to basically say, here's what you did wrong. Or if you are the sender, it'll outline what you think this person did wrong to either infringe on your rights, like a copyright or a trademark, or if they're breaching a contract they have with you, or if you are the one that breached the contract. Usually it'll start out with a with the claim, which is we are alleging that you did A, B, and C. Um, Usually, this claim also involves a bit of an explanation on how your actions would constitute infringement or the breach of contract. Basically, just explaining, hey, you did this thing, and this is what it's causing to me now. Or obviously, if you're the sender, it would be the opposite. For supporting facts and legal citations, that's usually what comes up next. So once you write out the claim, usually what comes next is, here's all of our evidence to support this claim that we made. It could be like screenshots, it could be like a video of, you using the trademark or something like that. So it'll usually involve some sort of like supporting facts. Often it'll also have that legal jargon that everyone loves so much. It'll list, statutes or case law references, whatever it is that you are in violation of, showing you that they have a legal basis to pursue the claim. Generally, it will end with their demands. So some demands could include instructions to most often stop the use immediately. They will also generally ask you to either destroy or remove the unauthorized materials. For example, if you're using someone's copyrighted photo on your website, they'll usually ask that you remove it from your website. Um, Most often, cease and desist letters also include a demand for financial compensation, however much the sender believes, these claims are worth. Um, and a lot of the time, it will be grounded in case law or in statutes. There are statutory compensation amounts for things like copyright infringement, et cetera. Or it could just be taking a corrective action. So this usually happens in the context of a breach of contract where, hey, you were supposed to do A, B, and C and you didn't. Please correct it immediately, right? That's generally what would be in a cease and desist letter. So here we have a fun example from our friends at Netflix. This was sent to the Emporium Arcade Bar, and this was when they launched their Stranger Things pop-up bar. The obviously the counsel for Netflix was trying to be fun and a little funny on this one. So this isn't super typical. Often it'll just be boring legal jargon. But we wanted to use this one because it's a little bit more interesting. So you can see he like lays out the claim. He says, hey, this is what you're doing. This is why you shouldn't be doing it. It infringes our rights. Here's what we ask you to do moving forward. So that gives you an idea of what a cease and desist can look like. So, a lot of common reactions to receiving a cease and desist letter. Everyone can kind of react differently. Some might immediately go into a panic and just start complying with everything and wanting to prevent any further action without actually stopping to take a look at whether they actually did the infringing action. And that's important where you might have rights to this mark, or you might be able to use a copyrighted photo under fair use, or you may have bargaining power under a contract that you are ignoring because that fear is yelling at you. So sometimes fear and immediate compliance is the initial reaction. The other side of that spectrum is dismissal and ignoring it. I have personally seen on social media people saying, this is a scam, don't worry about it, it's not legitimate. And they just ignore it, right? And then the downside of ignoring it is that that can cause something to turn into a full blown lawsuit, which is going to be a lot more expensive and a lot more time consuming to defend. So neither of those initial reactions are perfect, right? So, what we recommend are steps upon receiving a cease and desist letter. First, don't do the panic thing. Just read it carefully, figure out what exactly they're alleging that you're doing, why they think it's wrong, and what they are asking you for. Take a logical look at what you actually are doing and see if maybe they're right. Or if you completely disagree, then you know, reach out to an attorney and have someone help you evaluate your possible path forward with this. One of the most important things that we always recommend you do is preserve all relevant communications and evidence. So, for example, harking back to the copyrighted image on your website, take your own screenshots and show us how you're using it before you take the photo down to comply with the cease and desist, right? It's important if you do end up hiring someone that we can see exactly the way that you were using it, and screenshots will really help with that. So save your original cease and desist or demand letter, save any prior correspondence about the same subject. Maybe you did get permission from them and now they're just saying, no, I never did that, right? Keep that, keep any other relevant materials, document any other evidence you can think of, and try to avoid at all costs deleting or changing any files or materials related to their claims. This can not only hurt your position when it comes to strategizing with your attorney, but it can also end up backfiring on you, and deleting and altering materials that may be used in a future case is just never a good idea. Um, and then the last step, we always recommend that you reach out to an attorney. Attorneys can help you assess your options, see if there's maybe, like we said, fair use could be at play. Maybe you have a defense you can use. So attorneys are there to help you actually assess their claims, see if they're valid, and formulate a strategic response. So that's what we always recommend.
Okay, so like Caitlin said, you should don't panic. Everyone stay calm, and read the cease and desist letter. I don't know about anyone else, but sometimes when I have to read either like really boring or like dense things, I will definitely read without retaining anything, and it takes me a few tries. So if if reading through a cease and desist letter might seem challenging, or if you have it in front of you and you're like, I don't know what I'm looking at, here are some suggestions or guidance. Basically, you want to read and analyze the cease and desist letter in a way that you can actually understand the legal basis. Look at and identify the legal claims that they're talking about. Is this a copyright infringement issue? Is this like hey, you didn't comply with what you had agreed to in the contract, and therefore contract law is implicated? Review any of the cited statutes or a case law or other legal references that support what they are claiming against you, and try to understand, okay, what are they actually arguing, and like what are they saying I'm in violation of? The next thing to do is then assess the accuracy of these claims. And like Caitlin had mentioned, usually they lay out facts that support their claim. It's your opportunity to now look at those facts and see if they're true, or see if this person is just making things up, or saying things that they heard and not necessarily know. That way you can actually figure out if the sender's legal claim is valid. Are you truly infringing? Did you do it knowingly? Are you actually in breach? Or can you sit back and say, oh, this person has no idea what's going on? That is definitely dependent on the facts that are being used to allege what you're doing wrong. And then based off of that, now's your time to identify if what they're demanding is excessive or unreasonable. Say, okay, fine. Maybe you shouldn't have used that image, and this is all right, this is copyright infringement. Are they asking for something that's proportional to the alleged violation, or are they going?
A fun one, because we've seen people put crazy amounts of money.
Oh, yeah.
They want.
Yeah. There's a whole analysis that kind of lets us figure out what exactly they might be entitled to based on the statute. But if someone's coming out like, you owe me $1 million, and also like pain and suffering for the emotional turmoil that I've gone through, okay, hold on, we might need to reassess. So the question to ask yourself as you're looking at this demand is this reasonable, or is this person actually trying to exploit me? And if any of that sounds difficult, that's why you hire an attorney. And I know you're listening to a law firm talk about this. Like, yes, we will talk about the importance of seeking an attorney, not only because it is our job, but because cease and desist letters actually do concern or like involve complicated legal matters like copyright and trademark, and like the complexities of how a contract or an agreement is written. So having someone that knows how to analyze these issues in these complex legal matters could help strengthen your position, or make it not so bad if you actually are infringing or breaching a contract. Not only can we help you navigate these legal challenges, but we can actually determine their validity and their strength. And like I mentioned before, evaluate your position and identify any potential defenses based off of the information that you give us or an attorney in general. But to address a cease and desist letter, usually we or any other attorney will craft a response that can lead you to a resolution, whether it be settlement, whether it causes the other party to be or to back down, because actually you're right, we messed up. But yeah, crafting a legally sound response can help avoid any missteps or help prevent escalation. Essentially, having an attorney reduces exposure to lawsuits, financial penalties. We can guide you and help you figure out how best to tackle a cease and desist letter should you get one, and then just maintain control over your entire situation. Pop quiz. Oh, I have to launch it. Hold on. 1 second. Okay, so pop quiz. Let me launch it right now. Cool. What is the primary benefit of crafting a legally sound response to a cease and desist letter? This should be easy because I just talked about it. Oh my gosh, it's fine. Wow, everyone is so good.
I feel like I'm in law school again, you guys.
I was just gonna say, I'm like, I feel like I'm the professor in a law school.
Yeah.
This goes back to a 2020 Zoom School of Law when all my classes were online. Oh my gosh.
Lord, I can't even imagine.
Well, it's like this.
Did everybody vote?
Almost everyone. Let's see, 61%. All right, I'll end it. I'll end it and then I can share results. All right, so popular answer was D, to avoid missteps that could worsen the situation. Ollie, is that the right answer? It is the right answer. Yeah. Um, yes, if you have a legally sound response, like cool, you can avoid missteps that could worsen the situation, whether it be incurring additional financial penalties, taking something down when you didn't need to and losing out on potential revenue, or accidentally escalating something into litigation because maybe you thought, oh, like I don't need to respond, and then boom, you get hit with a lawsuit. You don't want that. So yeah, great job, everyone.
So Kyla touched on this a little bit, but we're going to go through a little bit deeper. So, how do attorneys evaluate risk and exposure? So that is essentially most of our job, is evaluating what the legal exposure is, what your potential liability is, and what the risks are of taking certain actions. So first, we'll start with legal and financial. Often we ask ourselves, what are the potential consequences of compliance versus not complying? Um, and the biggest question of all is, does this claim have merit? Is there a basis to challenge it? Do our clients have a solid defense that, eliminates all of the liability? Those are the first questions that we'll ask ourselves before we dig any deeper into the rest of the letter. We often investigate the sender's history. So this is kind of twofold. This is from the person actually claiming the infringement or breach of contract, and the law firm sending it itself. So this is a twofold inquiry. Um, for the sender's history, we usually ask whether they have a pattern of aggressively pursuing legal action. So we all know of certain, famous people that are very, very protective of their trademarks or their copyrights. Like Taylor Swift comes to mind, right? She's very proactive in protecting her IP portfolio, rightfully so. And there's a lot of other music artists, writers, etc., that are very, very proactive in this. So we will look at how many other lawsuits have they filed. Do they often pursue further legal action, or is it usually just they send this letter, things are resolved, and they let it go, right? So we'll look at all of those other things, whether they often try to resolve it through settlement or they try to resolve it by pursuing a lawsuit. Um, that leads us into evaluating different methods of resolution. So if they often settle informally, that indicates to us, okay, they may be open to negotiating a settlement. Let's pursue that route first, right? Um, and then other things are kind of like if they are very aggressive and they are very litigious, then that's going to alter how we advise our clients to proceed. If they often are very litigious, we warn our clients like, hey, you should probably consider just trying to settle this informally because they are likely to file a lawsuit and that's going to be harder to fight. Um, so then that leads us into weighing the risks of litigation. So is there a good chance that they're going to escalate it to court? How does that compare to alternative resolutions? Are they only willing to settle for, like Kyla said, $1 million? Because most likely a lawsuit will probably cost a little less than that. And if they're not automatically entitled to that amount, statutorily, then you can probably knock them down a little bit during settlement. So we factor all of those types of things in. We evaluate the risks and exposure, what your liability is, whether you have defenses, etc. So that being said, you do have a few different options for your response. You can comply and stop the conduct. This is most often what we advise our clients to do when they realize they actually have engaged in infringement, whether it was an accident, or intentionally. We always advise that you cease the alleged infringing activity. This is usually ideal where, again, that claim is valid and the the potential for them to continue pursuing the claim is going to hurt you more than just saying, hey, you're right. Hey, I didn't realize that you had a copyright. I messed up. Sorry, can we resolve it? Right. Um, Oftentimes, even when you do pursue that settlement route, it doesn't mean that we're automatically agreeing to that $1 million demand that's ridiculous. We always try to negotiate for better terms. That might include a lower settlement payment or no settlement payment at all. It could include paying a certain amount, but getting a license to continue using this piece of art or whatever it is that you were using. Um, so, again, this is also more beneficial when we recognize that the claim does have some merit. Where the claim doesn't have much merit and we say, hey, you're totally covered in this defense, bring it on, basically. Then we could challenge it. We'll usually write a response and we'll say, here's all of our reasons why you're wrong. So that's the other way that we can respond, right? Of course, you can always choose to ignore it, but like we said earlier, we usually don't recommend that in like 99% of situations. So we don't recommend that you ignore. So there are various financial and reputational considerations to take into account when you are looking at compliance versus fighting. Compliance often can avoid that costly litigation. It can usually preserve your reputation. Most often, settlements are confidential, so you don't have to worry about a public lawsuit, bringing bad press or bad publicity. But the other side of the compliance is that it could involve financial losses, things like that. We usually try to mitigate that. We also try to mitigate the potential admission of guilt or at least keep it confidential, right? Um, the pros of fighting is that it can protect your IP, it can protect your defenses. Like if you do have a right under fair use to use this, you want to protect that, you want to preserve that. And it shows resistance. The cons, obviously, like Nina mentioned, legal fees. We know no one likes those, but legal fees could be a whole lot less than the financial losses it would take if they actually pursued litigation. Um, it could be reputational damage if it's publicized that you were fighting, things like that. Um, and then there's always a risk of escalating to litigation. So generally speaking, compliance involves a quicker resolution, a little bit more minimal risk. Fighting can take a higher risk, but it can also have an unpredictable outcome. So it could be time consuming. You could spend a lot in legal fees, but it could save you that $1 million settlement demand and you could knock it down to like 10,000. So when you look at saving $990,000, that's a lot, right? That's a big difference. I mean, math is not my strong suit. So we always take into effect that cost benefit analysis as well, and that informs how we advise our clients. All right, let's do another pop quiz.
Okay, it is launching. Oh, where to go? Why? Why can I not launch this one?
Because I have really bad luck, that's why.
Oh,
Technology can
because I'm
smell my
sharing.
fear.
Got it. Okay, we're launching. It's being launched. We're good.
Okay, so what is one risk of escalating a cease and desist letter into litigation? Hopefully we're really driving home these points.
This is what we do. Let's see. Let me wait a little bit more. And okay, half participation. All right, I'll end the poll. So the most popular result was A. Let's see. Yeah, this is truly like class. I feel like I'm back in law school.
You
Thanks.
guys are really good students, by the way.
Yeah, well done.
Okay, so we kind of went over what you should do when you receive a cease and desist letter, what you do when you first get it, and then the possible paths that you have after receiving one. Now the question is, when should you send a cease and desist letter? Well, if you have a valid claim for one, and you want someone to stop doing something, you should probably send a cease and desist letter. Valid claim, well, first you have to identify if you have a valid claim or not. And this can include intellectual property infringement. if you own a trademark, if you own a federally registered trademark and you see someone using that trademark, um, or using something very similar to your trademark without your permission, without your knowledge, you can send them a cease and desist letter that tells them, hey, stop. I own exclusive rights to this trademark. Another valid claim that you have is defamation. Say you are a reputable producer or a casting director in the industry, and someone is going around telling everyone or telling other people in the industry, like, oh, this person is terrible to work with, never hire them. They did this XYZ, and it's not true. These false statements harm your reputation or your brand or your business. So you can send a cease and desist letter saying, hey, stop. This is defamation. Another one that we normally send letters for is breach of contract. Um, Someone fails to pay pursuant to the agreed upon terms. Someone is using development materials when they never exercise their option, and you have a clear clause, or you have a clear clause that says you can't use development materials. You can't use a sizzle reel because you don't own the rights to my work or my script. So you can send a cease and desist letter when you have a valid claim. You should not be sending one if it's just for personal grievances. If you don't have true legal standing to do so, and just to make unreasonable demands. If someone is just really annoying, maybe don't send them a cease and desist letter. If it's a personal dispute, if there's like some relationship issues going on, maybe don't send a cease and desist letter. Let's keep it to legal matters. Those will be more valid and are more likely to hold up in court. Yeah, so to briefly discuss what we do and like how we draft an effective cease and desist letter should you have a valid claim. We really try to make it clear what the legal basis is and the demand of the letter. We try to explain the law or the agreement or the clause that has been violated, and then specify what we want that the recipient to do, whether it be to pay the remaining amount that is owed, stop using the trademark that's been registered, stop using the photo of the person's artwork just in their book. We try to be clear. This is the legal basis. Stop doing this. Tone is very important when writing a letter too. It Being aggressive can work in some instances, but being overly aggressive can cause someone to panic and escalate the situation or harm future negotiations. So, in general, we try to maintain a firm but professional tone to avoid unnecessary conflict and allow some room for negotiation and resolution. And of course, we always want to avoid empty threats. We want to be clear about the legal actions that you will pursue and are entitled to, and make sure these actions are realistic. If empty threats don't do anything but like lower your credibility, it can cause the recipient to be like, oh, you know what? They don't actually mean this. I'm fine. When really you want to resolve the situation and move past it.
And by the way, people usually can figure out who's serious and who's not. One of the kind of telltale signs is if you don't actually hire a lawyer and you write the cease and desist yourself. Just a little tip for you.
So I do want to leave some time for our Q&A, so I'm going to try to go through this quick. Um, so there are certain situations where using cease and desist letters can actually strengthen your IP rights. Like we very quickly touched on earlier, a lot of intellectual property rights, especially things like trademark registrations, they require you to protect your intellectual property. And regularly sending these letters for trademark infringement shows that you are actively protecting your intellectual property rights, that you are not letting people just roam free using, Starbucks logo or something. Um, so a lot of times places like the USPTO, who registers all trademarks, they will require you to show that you are protecting it and that you've maintained your registration. The other half of that sword is something called genericide. So genericide is basically where a trademark that was registered or is trying to be registered becomes so generic that it loses its distinctiveness. So certain things that might come to mind are like chapstick, the chapstick brand. Everybody just calls that chapstick, whether it's the chapstick brand or Burt's Bees, right? So that's something that kind of faced a little bit of genericide. So being able to enforce your trademark rights helps prevent that as well. Another thing is if there does happen to be some kind of USPTO dispute or some kind of litigation, having a paper trail of you sending these letters and showing that you are actively trying to, number one, protect your rights, but also showing that you try to resolve the disputes before just jumping to a lawsuit, right? All of that can strengthen your case. So judges like to see that you tried informally to resolve this, it didn't work. That's why we're in court now. Most people don't take very kindly to just a random lawsuit without having any back and forth first. So it can, sending these cease and desist letters can help strengthen in various different ways. It can provide evidence. It can show that you are exercising ownership and control over your rights. And it can help if things do accidentally run into litigation. So here's one more pop quiz for you guys. How might a cease and desist letter help strengthen your intellectual property rights?
Just launched it. The votes are coming in. We have a clear leader. Oh, actually, we have two. Okay, it's between A or B right now, but the leader is B. Let me end the poll and share results.
And we're trying to get a little bit harder, trying to throw a little bit of curveball in there for y'all. But this one is B, so it will show that you are actively protecting and enforcing your rights. Increasing the value of your IP is not, I would say, wrong, but it doesn't actually add to the monetary value. It just helps you protect it from losing any value.
Alternatives to sending a cease and desist letter. Like Caitlin said, I do want to make sure we have time to address questions. So I'll go through this quickly. You don't have to send a cease and desist letter. Depending on the situation, that might not be the best way or the fastest way to approach a resolution. Sometimes you can actually just contact the infringing party directly to be like, hey, can you stop? And sometimes they're like, oh my God, you're so right. My bad. You can also figure out some creative solutions like, how about can you credit me? Can you pay me this fee and we'll consider it done? Other alternatives are to mediate, to engage in licensing discussions to see if you can memorialize whatever has been agreed to when it comes to licensing and licensing payments. Or if both parties are willing, a settlement can just be reached through good faith negotiations. Usually, though, sending a cease and desist letter is either the first or maybe the second step, especially if they are unresponsive to you reaching out like this informally. But there are alternatives. Notable cease and desist letters. This was I think, yeah, this was the letter that was on screen earlier. This was Netflix sending a cease and desist letter to a fun Stranger Things pop-up bar. It was playful, but basically they were like, hey, we love what you're doing. It's not authorized. Can you not let it last longer than 6 weeks? And the manager was like, you know what? Yeah, you're right. They stopped. But it introduced people to Stranger Things.
We do have a couple of frequently asked questions, but I do think that we have a question in the Q&A. So we can go with that one first. So Guy asked if you have had your project about a public figure vetted and you know you're working within the law, is it possible to countersue for the legal fees involved in defending it? That is a very good question. So if you are already in the litigation process, you can always file a counter lawsuit. Um, and in that counter lawsuit, you can request that they pay for your legal fees. Usually that only happens if you receive a favorable judgment in the litigation. Um, so usually if you receive that favorable judgment, then you can ask that they pay your legal fees. Sometimes the judge will award it, sometimes they won't. Um, Part of the settlement negotiations process is deciding who will pay what side's legal fees. So we've seen that before as well. When you go into settlement, part of it is you pay my lawyer's fees, and then maybe a little bit extra or maybe not, and then we'll call it even, sort of a thing. So there are a couple different options. It depends on the situation.
We did have a couple of questions included, but I think maybe we have time for one more and then we'll wrap this up. You will be receiving this PowerPoint. So if you miss out on anything, you can see it at the end. But yeah, we'll do one more question and then probably wrap up. Let's see. Caitlin or I can take this, doesn't matter. Okay. Can a cease and desist letter be challenged in court? Yeah, it can be challenged in court if the recipient believes that the claims are invalid or if they have a defense against the infringement. But the whole goal is to not get there to begin with. You want to address it before you ever get to court. You want to negotiate or settle the issue so that you don't need to go to court. But a letter could be evidence or it could provide the basis for why you're going to court. But yeah. Yeah. All right.
Thanks, Kyla. Thanks,
That's
Kate.
it. Yeah. Thank you everyone for coming by. If you guys have any questions, feel free to reach out to any of the links or contacts that are on screen right now. You will be receiving this PowerPoint and also a recording if you ever need to reference it. But please, if you have any questions or would love to chat with us, give us a call, email us. We'd be happy to help. But yeah, thank you everyone. Have a wonderful, wonderful day.
Thanks everybody for
Hopefully this was educational.
Yeah.
remember, don't ignore those letters. Bye.
Yeah.